Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you're my everything. Say, I call you Lord, my provider. I call you.
And it is the 16th day of March 2024. Welcome to the Community and the Law, where we discuss all issues pertaining to the law here in the UK and outside as well to some extent. The new statement of changes to the rules, what are they? How do they affect you? And how are you able to navigate these changes to stay on the right hand of the law? The Community and the Law is brought to you by BWF Solicitors, and we're going to it together next.
Private Client Services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome to another edition of the Community and the Law. My name is Uriku Owusu-Frimpong. It is the 16th day of March in the year 2024. The UK government has always, around the end of the year and starting the new financial year, has always been bringing in changes to immigration rules and some laws in the country. What is on discussion this afternoon is the new statement of changes to the rules. We're going to look at how it affects you and how you're going to navigate these changes. We also have updates for you in the community. The Community and the Law is brought to you by BWF Solicitors, our trusted partners when it comes to the law. They are located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London, N15. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. You can contact them by telephone 0208 493 7340 or 077 127 61884. Now, BWF Solicitors is inviting you to come and just leave your burdens upon their shoulders. If it's about immigration issues, they are masters. If it's about land and property issues, they are masters, especially when you'd want to acquire property outside of the UK. In Ghana, you can trust BWF Solicitors to guide you through that. Wills and probate. Yes, we start and we end. We come into the world and we go out of it. But when you're leaving, what do you leave behind for people? Have you thought of how you do your will? Contact BWF Solicitors. For employment issues and all the other bits, when it comes to the law, it is BWF Solicitors. So, ladies and gentlemen, as I welcome you to another edition of the Community and the Law, I want to say thank you to BWF Solicitors. And when we come, we will delve straight into the updates. What is in the nugget box, and of course, the discussion. You are welcome to another edition, I should say, of the Community and the Law. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet 𝗖𝗢𝗠𝗨𝗡𝗜𝗧𝗬, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients in the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner 𝗖𝗢𝗠𝗨𝗡𝗜𝗧𝗬, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
BWF Solicitors, thank you very much. And to you that has tuned in, thank you. We're live on Facebook and YouTube and all the other social media platforms. BWF Solicitors and BWTV. So when you log in, please go to the comment section, announce your presence, click the notification button so that whenever we put content on, you'll be notified and will not miss out. And then also pick up the link and share with your friends so everybody would have the benefit of the knowledge we are going to share this afternoon, coming right from the auspices of BWF Solicitors, trusted partners when it comes to the law. BWF Solicitors is this law firm that I trust, you can trust, and people have had the experience of using their services, and the reviews are many. I would want to encourage you that if you have had that wonderful experience with BWF Solicitors, just give us a review and we will acknowledge that and say thank you as well, because you have found a good thing and you want to share with others. This afternoon, we're going to look at one very important thing that has happened. I mentioned earlier on in my introduction that new things come by way of the rules and regulations and the laws in this country. Now, when these changes come, they come in the form of a statement. There's a new statement that's been released and issued, and is talking about rules and the changes that have to take place. How are these affecting you and your family here in the UK? Now, the senior partner of BWF Solicitors is so very well experienced in all these things, and he's going to be our guest and resource person this afternoon. So, with your permission, ladies and gentlemen, let me welcome to the show the senior partner, BWF Solicitors, Mr. Bernard Owusu. We call him Uncle Ben. Uncle Ben, good afternoon.
Good afternoon, Craig.
Thank you very much for joining us. We're so very privileged to have you all the time. Saturday afternoons are quite valuable to families. So if it is that we get you out of the house, we're so privileged, and we thank you. So we want to thank the family as well for releasing you for us.
Thank you. It's always a pleasure to be here, to be serving the community. And we are grateful to all those who've joined us today. Hopefully we'll do a deep dive, very copious document, 276 pages.
Oh.
But we'll break them into bite size and
Good.
see whether we can help everyone.
Yes. So just get ready, and as we dive deep into it, we definitely would have the opportunity of learning so many things. And this afternoon, with the main man here himself, he is going to help us do that. So once we are ready, we're going to take another break. Say thank you to BWF Solicitors, and we'll come with the nuggets. And the nuggets is released very early in the week. That tells you things that you need to note. And also, when there are any updates, BWF Solicitors is so gracious to throw that in the community, in the space, and let us have that knowledge. So we will stay, as I usually say, on the right-hand side of the law. And then again, they tease our knowledge and find out whether we have been following and would get some of the questions right. So they set out a scenario and set out questions around it, and we get you to look at that and answer it. We will be doing that on the program today. It's the community and the law.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Well, thank you very much for staying with us. Now, let's do a bit of housekeeping. I said earlier on that when you come on, please announce your presence and we'll acknowledge that. And then again, I would want you to pick up the link, share, so that people will also have the opportunity of enjoying what you are going to enjoy in the next hour or so. Let's get onto the platform and see who is there. I welcome them. Hello to Riku and Koben, this one from Ademununkum. The next one here, Tilly Duma says, hello, lovely family. Well, Tilly, thank you very much for doing what you do all the time. Regina Mensa, good afternoon. Reggie, how are you? I know you're doing so very well. Sandra Fraser, good evening, says, yes, Sandra is in charge of our front desk at BWF Solicitors, and she does her job so very well. Thank you, Sandra. Now, Najima, the class prefect, Najima says, please share, and share. That's the key word, share. Daniela Chayman-san, good evening, everyone. Good evening, Daniela. How are you doing? I know you so very well. Sandra says, yes, fellow viewers, please share when you join. We appreciate all your support. Thank you very much. Thank you too, Sandra. Thank you for doing what you do all the time. Yes. So let's go on. Let's see what was giving us as our nugget for the week. So we start with that and we say not meeting the minimum income requirement should not prevent your partner from joining you. Why are we saying that, and what is the new thing? Where the minimum income threshold cannot be met using the sources specified, a credible guarantee of sustainable financial support, an employment or self-employment offer, or any other credible source of income available to them will meet the test. And now, this is quoted from paragraph Gen 3.1, 3.2, that is a financial requirement specifications in the rules, and it's from the Home Office Family Policy on Life as a Partner or Parent 2024. Now, let me quickly go to Uncle Ben and ask what this one is saying. Is it part of the new things that have come? And the particular emphasis on this one is, I believe, helping people to know what it is that the financial requirements are and how they can meet that. So again, let's see what this one says.
Okay, so this week's nugget talks about alternative source of proving the minimum income requirement under the rules. And you can see that everything we do is calculated to solve a problem.
Right.
Since December, we've been told that there was going to be an increase in the minimum income requirement for spouses and also for skilled workers.
Right.
And we know that from the 11th of April, the current threshold of 18,600 is going up to 29,000.
Mm-hmm.
So what we do as a firm is to say, well, you are confronted with this legal challenge. How do you solve it? You only solve it by using tools that has already been provided to you, either obvious to everyone
Mm-hmm.
or not quite obvious to everyone. So there are those that are obvious, which is basically that go and work and earn the money.
Mm-hmm.
Or there are those that are also obvious, which means that save and provide the evidence. But those that are not so obvious, like the issues in relation to what we've just discussed, which is basically that under the GEN is one of the exceptions to the rule. If you don't meet the minimum income requirement, what can you do?
Mm-hmm.
What you can do is what the law is prescribed, and what the law says is that if there are particularly compassionate circumstances, that's one we spoke about that last week
Right.
or the week before. But in this case, there are three things that they've mentioned. It's an offer of a guaranteed source of sustainable income.
Mm-hmm.
So the first of all, that particular source of income, we looked at the 6 sources of income. We talked about the 2 A and B, which was employed income, salaried and non-salaried. And we talked about the savings, the pension, investments. Yes. So this is another one. And this one is basically for people who may not have the energy and willpower to go out and work, but there are other sources of income. For example, if you have a sister or a brother, who needs their spouse to be here, and you are earning quite enough, and you can promise and show the evidence that I can provide this regular income to my brother-in-law if and when he comes. And if they find that to be 1, credible, 2, guaranteed, and 3, sustainable. And these are terms that we all must note. So it's not just going to bring Kofi Antubam. Kofi Antubam, good evening. Just bringing Kofi Antubam to say that Kofi Antubam will offer me this. And Kofi Antubam hasn't have a credible, guaranteed, sustainable source of income. Then it becomes a problem. So
that if we say credible, how I've always said, I think that expression is now gaining a currency in the community. Evidence is the name of the game. How do I prove that this source of income is 1, guaranteed, credible?
Okay, so first of all, if you want to prove a source of income, there can only be one legal means of proving that. And it will be either your bank statement, your financial statement, your pay slips, or your audited accounts,
Mhm.
including having filed your tax return and you either get your SA 302 or capital gains tax form 600. Those are the evidence you can use. So, for example, if I am supporting my sister to bring her husband, and I have maybe a savings of, let's say, about £100,000, and I've had it for a duration of about a year or 2 years, I can show that
Mhm.
I've got this. And the way to show it is by providing the bank statement. The other means that we raised was the promised income.
Mhm.
So somebody may not be earning the money now, but they've been offered a job by a credible, sustainable, guaranteed, verifiable source, and they can use that to show. There are very indicative factors which point to what we call the family life, sustainable family life. So Article 8, for example, is very, very relevant in this particular immigration topic,
Mhm.
but also the case of Lebanon, which is a court of appeal case. Although the case was not successful, the case said that in certain instances, if there are concerns that the decision will compel the settled partner or a child to leave the UK, then quite clearly that is a concern that the law must address. And that's why the Home Office has created this policy for people who otherwise cannot meet. So what we decided is that last week and this week and next week and the weeks ahead until we hit 11th of April, we're going to show people who unfortunately cannot meet the requirements, the new threshold. What are the means to use to provide evidence that if your spouse comes, you will be able to support them, and in a dependence who they come with.
Yeah, so we want to reiterate that not meeting the minimum income requirement should not prevent your partner from joining you. Where the minimum income threshold cannot be met using the sources specified, a credible guarantee of sustainable financial support, an employment or self-employment offer, or any other credible source of income available to them will meet the test. If you have any other questions and queries, please do not hesitate to contact BWF Solicitors on 0208 493 7340. I say the number again, 0208 493 7340 or 077 127 61884. Well, apart from this, I think there are other bits that came, and BWF Solicitors is asking us to take note of those changes and updates, and it's thrown into the community. Let's look at this particular one. Those partners unable to meet the new minimum income requirement can still apply under the 10-year route. Those unable to meet the requirement, which is the £29,000, may still be granted leave where there are insurmountable obstacles to family life with their partner continuing outside the UK. It would not be reasonable for their child to leave the UK, or there are exceptional circumstances which would render refusal of the application a breach of ECHR, that is Article 8. That is the Human Rights Convention bit, Article 8. Now, this is part of the statement of changes to the immigration rules HC 590. Well, I have read it as it is on the face value, but let's go for some explanation, Uncle Ben.
So once again, the emphasis is to provide means of achieving the same results by using different tools, which are legal means of meeting the threshold. The threshold is extremely high, even at 18 says. It's very, very high. So the current threshold is what we're talking about, but the new threshold is even higher. And therefore, I did broach this particular part of the law. As you can see, when you read the explanatory statement of the Statement of Changes 5 HC 590, it did say that in certain instances where people cannot meet the income threshold, they can rely on this. If you can show that they are insurmountable obstacle. The name is quite heavy. The word insurmountable means that, it's a hurdle that it's almost impossible to jump. Or in addition to meeting the insurmountable obstacle, or alternative to it, that a partner's life and that of a child may not continue in the UK if they insist on meeting the threshold. The other thing that you need to look at if there are exceptional circumstances. And this things, the other time I said, maybe as a result of medical condition, some other factor. It may be that they're providing care and emotional support to a child or a family relative in the UK. And therefore, if their husband is not allowed to come, it means that they will have to go back to that country. And these are factors that you can always cite in your application. For us, what we always say is that how do you deal with the cards that you've been dealt with?
Mhm.
This is what you've been given. It's just like you're born into a family where resources are very hard to come by. Yourself as a child, what do you decide to do? Very likely you say, well, I'm going to do well through education, and through that I'm going to be successful. It's the same way that we've got this legal conundrum. How do we solve it? The way to solve it is to use the same tools that the law has given us within both the guidance notes. As I said, there's a case called 𝗖𝗠𝗠𝗧𝗬, which is a Supreme Court decision, which says that the rules as they stand are a code of legislation which has been put together.
Mm-hmm.
In addition to the rules, we have what we call the guidance notes. They don't have the status of a law, so they are not really up there because they're not legislation. They are notes that have been written by the Home Office to help their caseworkers make decisions. But it's public. Mm-hmm. So if somebody relies on it, then the person can say that I had legitimate expectation that although this is not a law, you said I will have a better treatment under the guidance than under the law. And therefore, if I can show that the circumstances that you prescribed under the guidance note has been complied with, then the law will say that you have to enforce it and then grant the person leave to enter. So those are the things that we will put a lot of emphasis. So this is a bite size. We say it's a bite size. It's a one subject, with one topic. Mm-hmm. And there are things that I want people to note. So when we use the word insurmountable, also reasonable, exceptional, there are legal definitions which may pertain to individuals, but also can be applicable generally in the sense that if 𝗖𝗢𝗠 went through this and she had this result, it's very likely that if 𝗖𝗢𝗠 goes through the same situation, she will get the same results. And that's the way that you use this to make a general assumption in all cases.
Okay. Well, we have three other bits that were giving us, like I see, your BWF solicitors. Now let's look at this one. No more shortage occupation. The new statement of change to the immigration rules HC 590 announced today. That is the 14th of March, 2 days ago. This would do away with shortage occupation list in its current form and replace it with the new immigration salary list, ISL, from the 4th of April, 2024. Now, I would want all of us to take note of the date, 4th of April, 2024. Now, previously, we gave you the 11th of March, which has come to pass. We are waiting for 4th of April. A few things are coming up, and this is one of them. Uncle Ben, what is the say?
Well, so everybody knows shortage occupation. Currently, we've got an 85 occupation code. So we have the occupation code, the SOC. It starts from 210 up to about 800. There are 85 there currently. They're going to whittle it down to 21. Now, when you look at the shortage occupation, which we usually say shortage occupation list, SOL, and it's going to be replaced by the ISL, which is the immigration salary list. They have the same character, but a lot of things are happening in the space. And that is why we want to take bite size by bite size, because else, as you said the other time, you don't want to do information overload, else everybody's head is going to explode. So we're taking it little by little, but also the very crucial parts of this. So everybody will know that there's no more shortage occupation. What replaces it? Shortage occupation is an area of SW, which is a skilled worker route, which is basically that certain occupations are very, very dear to the country, either because the occupation is in high demand, it's a very specialized, skilled area, and therefore the government want to give it a different treatment. It gives you several benefits. Those that most people will be aware of is the fact that when you're on a shortage occupation, your immigration fee is reduced.
Okay.
When you're on the shortage occupation, you always get a discount of percent of the going rate or even the standard income threshold. And the standard income the discount is going. They've raised the standard income threshold and the going rate from 26,200 to 38,200 or 38,600. So it's raised it. Then it's also raised the minimum income requirement for all SW, including care, from where we are now to 26. But I didn't say care is 26. I'm taking it step by step. I'm doing something.
Okay.
Now, the reason why care, although it's 26,000, they will not pay 26,000 to them, is because they still get a discount of 20%,
20%, okay.
under the ISL, which is an immigration salary list.
Okay.
The MAC, Migration Advisory Committee, did an interim assessment in December last year, and they made this recommendation. The recommendation they made is that the shortage occupation is no longer useful, and therefore their proposal was for the ISL, which is the immigration salary list, which one is a whittled down list from 85 to 21.
Okay.
And two, the list will be certain salaries. So we start from 38,200 to 26,200. In between, there's 29,000. Within that list, where we've taken everyone on the SW or skilled worker, is that before, most people were on the 25 percentile of the standard income threshold of United Kingdom.
Okay.
So when you take the standard income threshold, they took the last 25% and applied this as a standard rate or a going rate for some of these occupations. And some people still have 20% discount on that. What they've done now is that they are now applying the 50 percentile of the UK standard occupation income threshold, and they call it the median rate. The median rate is what they've clocked as the 38,200.
Okay.
So as far as they're concerned, the average income in the UK, they've taken the middle part. So the average is usually, you multiply, you add all, and you divide by the number. It's about 38,200.
So let me get this clear. So when they say they have changed the threshold from a lower figure to a higher one, so it means that anybody that's going to be employed in that category on the list would have to earn that minimum amount of money.
Absolutely.
And they've taken that percentage, 20% discount off it.
Yes.
So it means that if somebody gives you a contract of employment and does not promise to pay you a minimum of 38,000, then you don't qualify.
Absolutely. So, and certain occupations, they are what we call the national standard income for certain occupations. So like for doctors, like for pharmacists, like for teachers, their pay rate is decided nationally by a certain whatever. That's why they're able to go on demonstration. Their income is different from everyone's. And then there are those who will be on the ISL, which is the immigration salary list. They are occupations like care, like bricklayers, plumbers, carpenters, joiners, tilers, and all those people.
Last week you mentioned that plasterers have been taken.
They've taken them off. They said the plasterers group have not justified why they should be there. So they've taken them off. But they've taken them off. Their median rate of income is about 26,000 thereabouts. So it won't affect them. Just that if you're not on the ISL, it means that you may be doing things like the resident labor test. So although the shortage occupation is going, and is going with about 64 occupation codes, it's going with them.
Okay.
It's only leaving 21. So that's a big blow for a lot of people. But the justification that the Migration Advisory Committee gave is that you cannot say you want this salary and then go and put them there. Because the only benefit that they say the shortage occupation gave people was a discount, the going rate, although there's something called, treasuring or tapering. So, for example, if somebody got a PhD or has got a STEM, they do get a discount, the going rate or the standard rate, they might only have to earn 70 or 80%. But the justification is that we don't need to have this many occupation codes on the list. And they're going to even ask the government to even tell them what exactly do they want to achieve with the ISL, which is what is replacing the shortage occupation. So watch the space. Many things are happening.
Okay.
And even in the care industry, in the carpentry and the building works industry, in the IT industry, in the executive publican managers, nursery, childminders, all those occupations, the rates are changing because the codes that they're using, they're going to use the 2023 code. We started with a 2020-10, we did a 2020, and now we're moving to 2023 codes. And with the codes, they reduce all of them. And the minimum standard of qualification would be a regulated qualification framework, which is a RGF3, which is equivalent to A level. And everybody will say, well, Uncle Ben, do they have to go and write exam? No, I haven't said that. But what I'm saying is that they said the occupations that ought to be allowed to bring people here should be occupations which requires a minimum qualification of RGF3, which is a regulated qualification framework, which is a framework that is used to determine what is the equivalent of this training or this qualification to the standard qualification. And it's equivalent to AS2 and AS1, which is A levels.
We still have two more items to quickly look at before we go into our main discussion. But interestingly, all these ones are dovetailing into our discussion this afternoon. You tuned into the community and the law, and we're doing our community updates. And we have our senior partner for BWF Solicitors, Mr. Bernardo, who's here with us and taking us through these changes that have come. There will be no additional requirement for dependent children under the new minimum income requirement, that is MIR. I would want to say again that, as Uncle Ben has said, watch this space. All these changes are coming, and look at the dates again. 4th of April, 11th of April, 2024. Now let's look at this. Under the new immigration rules, there would be no additional requirement for dependent children to meet the new minimum income requirement of £29,000. 23,496 for the for His Majesty Armed Forces. That means whether the couple have dependent children or not, they only have to show the £29,000 or the 23,496 from the 11th of April 2024 for all new applications. Now, operative word here, new applications. Then it is also saying that there will not be the need to meet the further requirements that earlier existed. This is me trying to become a lawyer, but let's go for the proper one.
Yes. So again, bite size to help the community. What's changing is that if we take the current position and we transpose what is coming, now you have to earn 18.6. If you're bringing your child, the first child is 3.8 and the second child is 2.4. So although it's 18.6, you end up being asked to earn about 32 or 34,200. However, under the new one, which starts on the 11th, it's 29,000 for everybody. So if you bring 10 children, it's 29,000. If you bring one child, it's 29,000. If it's just you, it's 29,000. So in that regard, it's okay. But still, it's a really high threshold for people who live outside Southeast. And again, for our community members who obviously do not do the high earning jobs that most people do in the Caucasian population. And therefore, we believe that even at this late stage, the government can still look at it, because 11th of April is still some weeks away. and we're hoping that if another government comes, they will not even increase it to the 38,000 that they wanted it to reach by 2025.
Right. Then the final one, ladies and gentlemen, before we, as I said, before we go in there, the new minimum income requirement does not affect those already on the 5-year route. The requirement of 29,000 for every other person and 23,496 for those in the armed forces will not affect those who are already on the 5-year route as partners, or those who made an application before April 11, 2024, if the application is subsequently successful. So exemptions, Uncle Ben.
Yes, so exemptions, or you can call it transitional arrangements. These are things that they put in the law to make sure that the law is not proactive, and that you don't backdate your law. Some laws are sometimes backdated, or they just stop everybody at the start of the law, just like they did with the students. This one is basically that currently, if you are here as a partner, you will continue to be on the 18.6, but with additional income for the children. If you go on the new one, then you will be on the new one with no additional income. But there's also protection. If you make your application as a spouse, and by spouse or partner, we mean those people who apply to stay here or come here as a fiancé, as an unmarried partner, or as a married partner. Those people, if your application is made before the 11th of April, but the decision is made even after that date, and the application is successful, you will stay on the 18.6 throughout the 5-year route. Again, that's something which is helpful. And it's helpful in the sense that at least you are assured that because I've made my application before the 11th of April, the law is not going to change. Because remember that in December, they were actually debating whether it will apply to the people who are already here or only those who are coming, from Ghana or whichever country. And it looks like the petition not to increase the rate, obviously they staggered it, and also the petition to say that the retrospective nature of the law is really not fair, and it may raise issues under judicial review for when it's unreasonable, or a decision that to the ordinary man in the street does not appear fair.
Well, you see, Uncle Ben said information overload. I'm not going to overload you, but there's something we need to really look at. These updates we have given you have all come as part of the changes that we need to anticipate and expect, and of course, live with. Statement of changes. What is that? Uncle Ben earlier on mentioned that there is a huge document, over 260 pages of that. What is that document saying? How does it affect me? How does it affect my family? How does it affect you out there and your family? Answers are up next on the community and the law. But in the meantime, let me also go to the platform and say thank you to a few people who have joined us, apart from the ones I mentioned earlier on. I know Sandra Fraser is asking people to keep sharing and giving her your details, telephone numbers and everything for BWF solicitors. Thank you very much, Sandra. Kwajado says hi. Kwajado is watching us on Facebook, YouTube, sorry. Emmanuel K, the numbers to call again. Yes, the numbers to call you can find on your screen, 0208 493-7345. I don't call now because we're going to go into the discussion. We'll come to the point in time where we'll activate the lines and you can call in. The number again is 0208-493-7345. You can send a text to 07399-208-468 or send a WhatsApp message, voice note, audio notes, as we normally call it, on 07950-422-780. 07950 422-780. Richard Enin, good evening, BWF. Good evening, Richard. Coco, good evening, sir. How are you? You give us a thumbs up to you again. Abigail Osemensa, good afternoon. Thanks for the education. Yes, there's more to come, so stick and stay. One pinning Adam, Uncle Ben all the way. Yes. Gerald Fodro on YouTube. Hi, you say. Thank you very much. We have Kevin Asamoah. Good afternoon, Kweku and Uncle Ben. Thumbs up 4 times. Thumbs up the 5th time to you. Santiago Munez. Good afternoon, Kweku and Uncle Ben. Thank you very much, Santiago. We have DJ Atoto. Good afternoon, guys. Good afternoon to you, DJ. Next one, we have Daniel Dakwa or Hene Great Work. Yes, thank you very much for joining us. A lot to learn more, so stay on. Yes, sharing is caring, so please share when you join the program. Further information for you as we go to take a break, and when we come back, we'll delve into the discussion. It's the community on the law, and this afternoon we're looking at the statement of changes.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back. Thank you very much for sticking and staying. We're live on BWTV, BWF Solicitors on Facebook, YouTube, and all the other social media platforms. The new statement on changes, you would have realized that before we got to this point, we've been looking at updates, and we looked at about 5 of them. Now, when we see the statement of changes, what document are we referring to? Why those changes? When are they taking place? And how do we find ourselves in these changes? Uncle Ben, statement of changes.
Okay, so statement of changes have a legislative effect, but they are not, debated in Parliament. It's put in Parliament just to mature. So they put it in Parliament on the 14th of March, and it will come into effect on the from the 4th of April. So that is what a statement of changes are. They are legislation that is usually drawn out by the Secretary of State for that particular department of government. So this one will be, it was done by the Secretary of State for the Home Department. This one is HC 590, and it covers a host of areas. So the first one that I want everybody to note is that people with EU pre-settled status or limited leave to remain have now been added to the domestic violence route, which leads to settlement immediately. So if you have an EU pre-settled status and you can prove that there's been domestic violence, now you can apply for indefinite leave straight away, even if your marriage is 1 day old. So that's very helpful for those people who are already in that category of immigration rules. The other thing that I also want everybody to notice, within the broad line of English language requirement, they've now added what we call international GSCE, whatever they call it. As you know, before, the English language, you need to provide a university degree, a PhD, a bachelor's, a master's, or you sit for the exams, or you've done your GCSE in England. They are now accepting international GCSE, which again is very, very helpful.
Right.
The other part, I want everybody to note within these laws is those who've applied for asylum. You know, even if a decision has not been made, you will be allowed to work, or you are allowed to work. Before, it was a shortage occupation, which was a list of 85 areas. Now it's going to be the ISL, which is the immigration salary list, which is 21. So again, that's something that people have picked up. Crucially, the financial threshold is there. The skilled worker route from 26,000 to 38,600, that has been done. I've explained why they've done that. They've gone to the median or the 50 percentile. Before, most people were under the 25 percentile, which is the 25, the last 25, or less than a quarter.
Less than a quarter. Because in the 25 will be 4 of those.
That's correct.
And you start from the very bottom.
Yes, now they put you in the middle.
Okay.
So again, that's another thing that I want people to check. The other thing that, again, I want people to know is that when you're making this application, sometimes you don't realize that with the income, if you've got a dependent child who is working, his income can count towards your minimum income requirement, and it will help you. For example, if you have to earn 18,600 plus 3,800, that's 22,600, I think. That income, if you're earning, let's say 18,000, but you've got a child, when you came here, he was 17, he's now 19, he's still part on your immigration, and he's doing part-time, he's earning 10,000 pounds. That can be added to your, that has always been the case, but that's an emphasis that, again, I want to bring. The final part that I want to highlight is what we've also discussed before. Now, in relation to the care people, and I want to put a lot of emphasis here, your rate is changing. So now it's about 21,600, which is £10.75. That is going up to 23,400. However, those people who are already on a COS, their income will continue. That is what they've said. And they don't have to change it. But any new person or any new COS that is issued to you will have to meet that threshold. So those, I mean, when we did the update, I covered most of them.
Yeah.
So those are the areas that I want people to know. If something else comes to mind, I will raise it. If you've got a question, I'll raise it.
Somebody just put this one. Daniela says, Uncle Ben, please come again on this one. If your marriage is a day old, you mentioned that, and for the benefit of other people, can we reiterate that? When you say if your marriage is a day old, what will be the situation and the condition that would give you that advantage that we're talking about?
Okay, so I mean, it was me just being naughty. Now, if you've got limited leave to remain under EUSS, you need to be on for 5 years to get indefinite leave. So if your marriage is 1 day old and you've got limited leave to remain, and you can prove that there's domestic violence, then you will get indefinite leave to remain.
Now, on this issue of domestic violence, if somebody is having limited leave to remain, the person has had evidence of domestic violence, reported it, police is giving a report and giving evidence and the rest of it. When the person puts in that application, would it necessarily warrant that a person could apply for a fee waiver?
Well, when you apply for domestic violence, you may qualify for the Destitute Domestic Violence. It used to be called the DDV. They've changed the name recently, and they've added students and skilled workers. They've now brought EU people with limited leave to go straight to indefinite leave, or before they couldn't get indefinite leave. If you can show that you're destitute, then you will get, you will not have to pay any fees. Else the fee is 2,885. But if you don't have the money, you can apply for a fee waiver, and you don't have to pay. But you do a DDV first, which is by email. They approve it, and when you're making your application, you just send the forms without any payment.
Okay.
Yeah.
Well, you can keep your questions coming through on the platform, or now I'm going to activate the lines 0208-493-7345. Daniela says it's now clear. Thank you very much for letting us know that it's clear for you. Once we have the boss here, you don't have any problem. So 0208-493-7345. Send a text 07399 208468. Your WhatsApp 07950422780. I've just had an interesting text here, maybe just something just to calm us down. Somebody says, I need to do my naturalization. The queue at Heathrow is terrible.
Yeah.
Well, don't behave like myself, because at the point I was whipped at the backside to go and to do mine so I could get that. But in any case, that's your discretion. 0208-493-7340. Let's pick this one. I think somebody sent that, and Sandra is asking the question for the person. Can a spouse use the funds they receive from government for their disabled child to meet the threshold?
So if you've got a disabled child, you're very likely to get what we call the carer's disability living allowance. And that is one of the 11 exceptions that you can use. We'll go into this. The whole of next week, I've dedicated Thursday, Friday, and Saturday to this area. We want to show you the little tricks that you should use. I mean, sometimes, somebody will say, if you want to hide things from people, put it in the book, and they won't read it. So we'll do all the reading for you. I mean, my hobby is reading. I just love reading, and I like to find new things. So we'll shine a light on some of these things. I think I'll try also do the video and share, because the video also helps, especially if it's in our local language. So I usually do the English and then the Tree version. Yes, you can. So, Kweku, as you know, when you look at requirements for the minimum income, it takes you to the specified evidence and income route. Below that, you come to eligibility leave to remain requirement is 3.3 and 3.1, 3.2, 3.3. That obviously comes in. So that's where you find the benefit, and all these benefits are related to disability. So you have the personal independence payment, PIP. You have the disability living allowance. You have the disablement allowance. You have the disablement pension allowance. You have the police disablement allowance. You have the military disablement allowance. You have the industrial disablement allowance. Please don't let me chew and pause all these things. It's an area that I like to use, but please, I've just given you the list. It doesn't mean that you just use the list, because in addition to the exceptions, which are what I call the passported benefits, because it's not every benefit that will take you to the threshold. You need to show that when you are applying for your spouse to stay, or you're applying for your spouse to join you, her presence or his presence will not cause you to go and apply for extra benefits. So I've got a client, an old man, he may be listening to us, I don't know, who's earning £2,000. He's a pensioner. So his combined income is PIP, universal credit, and pension. Now, the pension element is what will help him to bring his wife. He wants to bring his wife because he told me, he needs TLC. The weather is still cold, and he calls me around 9:30 p.m. So that can tell you, obviously that he wants his wife. And we've looked at it, he will qualify.
Okay.
There's another case that we looked at. He brought his wife and his son, and he wants to go and bring another son. The wife is working, but she's earning less. He's working, but he's earning less. Their son is working. Now, he didn't know that he could add his son's income. They want to bring another child. Because that he's working, the wife is working, and his child, who is now over 18, is working. I think this week's nugget is on this topic. So I've given you the answer. Because he's over 18 and is working, he can add his income to their income, and that will allow them to reach the threshold that the one who's coming to join. So we'll go through, we'll do it gradually. We just want to educate the community. The number of times that people are sitting on the answers but are still searching for solutions. And then when you say, but that's it looks very easy. So well, that is why we are a firm of solicitors. We're not agents who will rip you off. We try to point people out to go and read. And also, if you can't read, that's why we do the account videos and we do the account program. So please direct your friends to come and watch and ask questions. Any question at all, we'll answer them for you.
And then I would add that if you have any issue for any solicitor to deal with or any lawyer to help you deal with, just get to BWF Solicitors 0208-493-7340. They're on 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London N15. If you go by public transport on the train, Victoria Line to Seven Sisters, use exit number 2, and that will take you to the frontage of the Anna House. That's where BWF Solicitors is. And they help us with a lot of education, at least if you forget about anything at all. Remember that Saturday afternoon between 4 p.m. and 6 p.m. UK time, there is the community and the law as we're doing now. Let's go to the platform. 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧 says, how can I withdraw my EUSS application after being granted skilled worker visa? Uncle.
Yes, when you go online, you go to the application you made. When you log in, it will ask you withdraw or cancel application. That's all you do. You just click the button, and then it's withdrawn.
Okay. Yeah. Santiago Munez comes up with this one. He says that as a student doing my master's and a qualified midwife from Ghana, can I still switch the skilled worker with my partner after I complete my course in September this year?
Well, once the course is completed, with students, there are 2 requirements. It's either the course is completed or the course has ended. Mm-hmm. If you complete the course, it says complete. It didn't say successfully. Mm-hmm. So even if you get Z, or you get a 3rd class, or you get a pass, you've still completed your course. Once the course is completed, you can always switch. And we always urge people to switch. The question they ask is, with my partner? No, not with your partner. Because the law has changed since Monday, which is the 11th of March, unfortunately. I don't know why they like 11th of the month.
Yeah, because the 11th of April is there.
Yeah. Why do they do that?
Well, we'll have to find out. Drop any your questions, your concerns. Charlotte Adjuafuri, you're watching with us. Thank you very much. Santiago Munez, we have dealt with your question. Let's look at this one. Hello, good evening. My name is Kofi, and I want to ask a question. Kofi says that my friend and his partner made an application in November 2023 for indefinite leave to remain, and on the 27th of February, the man has been granted, but his partner hasn't received their decision. So what do you think is going on, please? They made the application together as well. Do you think the partner has something to worry about, or she should just wait?
Well, I think the partner should wait. Sometimes, people get overly agitated because somebody's made an application around the same time that they made theirs, and one person has received a decision and the other hasn't. The number of times that we get clients who say, well, I know my friend who did this and they've got it. We are all different. Every case is different. No 2 children or 2 applications are the same. So although the person is your partner, it was not considered by the same person. And that is why you've got your decision and they have it. The number of times that we make applications for parents, children, and siblings, and they all get their decisions at different times. It's a matter of patience. Just have patience.
Just have patience, and if you want any further support, I keep saying, I want to repeat, talk to BWF Solicitors on the 4th floor of the Anna House, 214-218 Tottenham High Road, 0208-493-7340 or 077-127-61884. This message will give you further details.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients in the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, 7 Sisters, London, N15 4NP. Main office line 0208-493-7340 or our emergency line 07712-761-884.
Okay, thank you very much. We're back. So take note of the numbers 0208-493-7340 for Uncle Ben's office, and the mobile number is 077-127-61884. But for the studio here on the program live, we are using 0208-493-7345. 0208-493-7345. Your text 07399208468. WhatsApp 07950-422-780. Now, Santiago Menez brings in a follow-up question, Uncle Ben. So if I switch to the skilled worker, can my partner make an application as my dependent on the skilled worker route?
I'm sure we can put this question to our regular viewers. They will answer it for you. Well, please, somebody should do that. And the rest, give it a shot. We all know the answer. The answer was basically that since the 11th of March, if you were not already on the route, you cannot bring a dependent. You cannot apply for a dependent. So whether the dependent is already here with you as a student or not, unfortunately, you've been barred. Your dependent, unfortunately, it's really sad that you came here with your family members, but from the 11th, you cannot apply for them to stay with you on a skilled migrant if you were not already on the route or haven't applied on the route. It's rather unfortunate.
Okay. Let's go to, I think I'll pick one from our YouTube viewers.
Daniela said absolutely not.
Yeah. Gerald Fojo, I have 2 children who have been here for 2 years now. Through BWF, of course, you're laughing out loud. Is there any restrictions as to when we can apply for their British citizenship?
Well, so as we keep saying, when a child was not born in the UK and they have settlement, and they want to apply for British citizenship. When you look at the law, it prescribes only 2 requirements. One of the requirements is that an application has been made. And the last requirement is that it pleases the Secretary of State to grant the application. That's it.
That's it.
There are other factors, which is basically the character issue. So if they meet the character issue, they've made an application, and it pleases the Secretary of State, he will grant it. However, when you go beyond the law, you look at the guidance notes, which again, I say is not a law When it pleases us, we use it. If we are unhappy with it, we challenge it. So in this case, it prescribes several things. It says that you should have lived here at least for 2 years and that your parents are or are applying for British citizenship at the same time that you're applying. But as I keep telling you, we make applications and cite grounds to use. There's one that I did. The child was playing for Barnet, and they did travel a lot to Europe. That's one. There was another one I did where the siblings were all born in the UK, so they were all British citizens. And anytime they're coming to the UK, he obviously, because of him, they all have to use a general route. And when they travel on school trips, again, when he comes, he has to use a different route with his teacher. So we used that reason and we were able to get him British citizenship. You have to make a case why your child has just arrived in the UK and you want him to become a British citizen. There's nothing wrong with it. There might be a justification because of peculiar aspects of his life, his education, or his social life. And that's why you want him to be a British citizen. And that will be accepted, yeah.
Well, keep them coming through. Let's go on the platform and pick up this one, after which we will do one of our voice notes. I will apply for indefinite leave soon, but I'd like to know if I do not work, but my husband earns £34,000 annually. Can I rely solely on his income?
Yes, so it's a household income. Your husband's income is also household income. It's either joint or single. It doesn't have to be both. Once you meet the income, you meet the income. 34 will meet the 18.6 because you're already here. That's why you're talking about indefinite leave to remain. And I think, yes, once you've got your 6 months pay slips, 6 months bank statement to show the income, employer's letter to confirm your role, your income, and how long you've worked there. And your last P60 is a historical record. That will be helpful to the application.
You can send a voice note to our WhatsApp number 07950422780. Let's pick up this one.
I'm showing on YouTube. Masamne Mapalanka Wapomna Many Mirapo Mapedame Warwaha. Na Yakaya Mama Yama may now for a customary marriage. Now with the certificate in the with a sending or how are you care? Many percent so na YouTube na na it's like you however because na it is a benefit says good to ma obakara kokana na zinsi and then you meaning na find na YouTube na me when videos people work at the master no obetum na why ebusun we share no certificate in it whatever Ministry of Foreign Affairs would have sent our cost of marriage. Now we told me about our file application. Let me so please tell me that no contact on it. That to them. So be to me pretty more bomb what I'm going to.
Okay. This person is saying that his head that if you marry, your partner would have to travel back to the home country. Both of them are here, and they would want to get the families back home to do the customary marriage, get it registered, get the endorsement from the Ministry of Foreign Affairs, so they could get the certificate here. The question is, can they use that to do any immigration application when it is that they marry? Essentially, he's asking that if marriages are contracted outside of the UK, are they valid here in the UK for immigration purposes, Uncle Ben?
Well, so we encourage our community members to use the best route available and the easiest and lawful route available to them. And that includes relying on your custom and your customary marriage is your custom. And because it's a recognized form of marriage, it's legal in the UK. So if your marriage was contracted in Ghana on your behalf and the Ghanaian law recognizes it, when it comes to UK, the UK government will also recognize it. The only thing that I ask people to do is to make sure that if people are contracting this on your behalf, that they gather the evidence that the ceremony is taking place. They've done the registration at the relevant metropolitan authority or district assembly. They've registered it, although registration is not compulsory. The only way that you can prove under our Evidence Act is basically by document. Even under the Ghanaian Evidence Decree, marriages can be proven by a marriage certificate. So you need a certificate under the customary marriage, which is the Marriage Act of, I think it's 1876. PNDC Law 111, which is a customary marriage registration law, has been captured there. And the Annex A is a customary marriage, and Annex B is a divorce certificate. Once they've got the statutory declaration, they've got a marriage certificate, they would then get two other certifications, one from the High Court and then one from the Ministries of Foreign Affairs and Regional Integration. When it comes here, now because we like to do things above board, and because there are scrupulous people in Ghana, we also advise that you show it to the Ghana High Commission for them to certificate it or to certify it. They will prepare a certification. It's just like an apostle, but theirs will be a letter with the necessary explanation, and then you can use that to make your application. For us, it's allowed. But just so that everybody understands, when you're making a spousal application in the UK, there's immigration requirement and legibility requirement, suitability requirement. So you have to meet all those. It's not only the paper that will allow you to make the application. You need to meet all the other requirements.
0208-493-7340. Or you can leave your comments on the comment section, both on Facebook and YouTube. We're live on YouTube and Facebook. BWF Solicitors, BWTV. The new statement of changes to the rules, how it affects you, and how to navigate those changes have been our main topic for discussion. And my guest and resource person is a senior partner of BWF Solicitors, proud sponsors and our trusted partners when it comes to the law. Let's pick up another one from the platform. It says, on behalf of a friend who is an EU, he has an EU indefinite leave to remain, married since 2018, but the wife joined him in 2020, and the marriage has broken down irretrievably. He has one child with her, but divorce was not done. He recently met a lady in Ghana that he wants to marry, and he wants to know if the new fee is going to affect him since he is an EU person, and can he bring the new wife 4 months after divorce? Can that affect the ex-wife when they're applying for the indefinite?
Well, I mean, if you're EU national, you married in 2018, or now in 2016, if your wife has been here for 5 years, if I'm a lawyer, I will obviously make sure that she gets her settlement. Once you've divorced, you can always bring somebody else if there's a person that you're destined to marry. So you don't have to wait for more than a day. If you divorce today, you can marry the other person the following day. Yeah.
Now, concerning fees, Uncle Ben, the new fees have taken effect. Somebody is asking me privately, is asking for naturalization. How much is it now?
Naturalization is about 1,300 and something. I will find it. And so, I mean, these figures, because you can easily check it. It's not one of the things that I memorize.
No, definitely. Well, we'll check that and get back to you. Now, before even we get to the end of the program, I will check and bring it back to you. What we're going to do now is to look at our nugget again. Then I would take a break and ask you to think about it, because I'm going to post that question to you where I'll test your knowledge and see what it is.
It's going to answer for me.
We'll be right back. Let's take an ad.
Okay, hold on.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208-493-7340 or our emergency line 07712-761-884.
0208-493-7345. We go into our lines and we have Emmanuel. Good evening.
Yeah, good evening.
Thank you very much for joining us. How are you?
Yeah, I'm fine. And you?
I'm very well, thank you. Yes, let's hear you. Uncle Ben is here.
Yeah, I have two questions. The first one is if the person is disabled and is receiving disability allowance,
yeah,
and he wants to bring a child to the UK, once it's not working, can he use the disability allowance, or is he going to pay for the immigration fee or any of the fees?
Okay.
So that is the first question.
That's the first one.
If you are disabled and you want to bring your child from Ghana.
So how would you want to do it? Do you want the answer to this first one first?
Let me ask the second one so that we can answer the
okay. Okay.
Yeah, the second one is on the naturalization. Yeah, naturalization and the fee. What are the fees? And let's say that the person is still disabled and then they want to do the naturalization. Does she have to pay for the fees or not?
Okay. So you want to know how much the fee is, and if the person has a disability, you want to find out if the person has to pay for the fees, yes. Right? Okay. And if the person is receiving disability allowance, how does that come to play in the applications as well? Is that correct?
Yes, that's correct.
Okay, I'll go ahead.
So when a parent is bringing a child, the financial threshold is whether they for what we call adequate maintenance. And the definition of adequate maintenance is that when you take out your rent and you take out your housing costs, whatever is left over should be able to cover the sponsor and any other dependent. So if they're claiming benefit and there's no other income, it's going to be very difficult to show adequacy of maintenance. But the benefit rate is specifically for that person. So obviously, if there's another person in the household who is earning money, then we can say that she would depend on her benefit, but there will be extra, maybe £70 or £75 a week left over, and that will cover the child. You don't have to be earning 18,600 or 29,000. It's just that you've got money coming in, which will be enough. The nationality fee is 1,580. Now, I always say 1,005, and my colleagues correct me that say 1,580. The £80 is for the ceremony. So you will have to pay that upfront. So it's 1,580. Unfortunately for adults, if you cannot afford to pay your naturalization fee, there is no fee waiver for them. For children, there is, but for adults, there is not, because they do not see British nationality as the only way that allows you to stay here. Because before you apply for nationality, you will have had indefinite leave to remain, which is equally good as a British citizenship.
Okay. Emmanuel, is that okay?
Yeah, so what are the supporting documents for the naturalization?
So for someone who's applying for naturalization, they always ask to state your employer. So, but when you're making the application, please just say that you are unemployed. That way, it's always better. They will not ask you for the employer. The first thing they will ask for is your name, your date of birth, the date you came to the UK, when you got your indefinite leave, whether you've been married before, the name of your wife or husband, the date you married, if you've been divorced before, the name of husband and wife, the date you divorced. One. The other part are your parents, your full name and date of birth and where they were born. The reason why they ask those questions is to determine whether you're already a British national. Somebody who was born in Atupai, I don't know how the person is a British national, but they still ask for those questions. Then the other crucial point is whether or not you've got any character issues. And finally, your referees. So when you're doing the application online, the forms will ask you various things. So you have to put the name of the referee, their date of birth, their mobile number, their email, their occupation, their British passport number, their address and how long they've lived at the address, and finally, the relationship. These are the things that you need to know.
Okay. Yeah.
Okay. All right. Thank you very much for your time, and thank you for coming on to contribute and ask a question. Yes, the lines are free now, 0208-493-7345. Now, people have asked for the fees, so let me do this for you now. Let's get to, yes, the nationality page for .gov.uk, and this is what it says. Naturalization, British citizenship. The current fee, or the previous fee, I should say, was 1,250. And remember, the new fee started from the 4th of October 2023. The 4th of October 2023. So, as Uncle Ben said, it's 1,500. The 80 fee, £80 extra is the arrangement of citizenship ceremony, including the administration of a citizenship oath and pledge at the ceremony. So you pay the fee in advance. So for your naturalization is 1,580. 1,580. Naturalization, British Overseas Territory citizens is £1,000. There's no change. Nationality registration as a British citizen adult was 1,126. It's now 1,351. Nationality registration as a British citizen child is 1,214. Previously, it was 1,012. So there's an increase of £202. Arrangement of a citizenship ceremony, as I mentioned earlier on, is £80. So then you pay that in addition to your naturalization fee. The administration of a citizenship oath or oath and pledge, where the oath or oath and pledge are administered at a citizenship ceremony or by a justice of the peace. I don't know whether, Uncle Ben, this is a bit different from what it is that we pay the £80 for.
Yeah. So it's different. But Kweku, when you look at this fee, it's not only applicable to UK. So it applies outside the UK as well.
Okay.
So not too long ago, all community members who wanted to become British citizens will have to walk into my office and come before me or some other solicitor. And then you come and swear before me. I had a Bible and a Quran. So, and sometimes you just affirm. So 3 oaths, and 2 oaths and 1 affirmation. That is still done outside. But these days you go and drink tea and eat biscuit. You know,
they give you a golden medal.
Oh, they give you a golden medal. Oh, I see. Yeah, and that's the £80. The £5 is administration of an oath. Why they want us to charge £5, I don't know. But that's usually for people who are like in Hong Kong and British protected territories who want to register in the country they are as British citizens. Yeah.
Okay. So yeah, I was going through the fees. Let me continue with that and finish quickly. There was another one: nationality registration, British overseas territory citizen, as Ankoben mentioned, £901. There has not been any change. Nationality registration, British overseas territory citizen, British overseas citizens, British subjects, British protected persons. If you're applying for a child, it's still £810. Then if you decide that you don't want the British nationality and you want to renounce it, the renunciation of nationality, you have to pay money. It's £372. It tells me, can you take it off? It tells me of this story where there's a father who called the son to come and testify before a stranger. This boy had committed that offense, and the father was like, okay, you are my son. I'm going to tell you to either tell me the truth or not. And said that in the local language. So what kind of crazy? So if you would want to tell the truth and be in trouble, that's up to you. Listen, why would you want to renounce it when you have gone for it already? Stay on it, because even that you're going to pay £372. That's just, by the way, a bit of a dry and politically correct joke. We are live on BWTV, and the program is A Community and the Law. I said that I was going to take a break, and when I came back, I was going to look at the nugget again. Let's look at the nugget that we gave you, and I'll drop the question. Then you start going through your mind and your depth of knowledge to see if you can answer it. Not meeting the minimum income requirement should not prevent your partner from joining you. Where the minimum income threshold cannot be met using the sources specified, a credible guarantee of sustainable financial support, an employment or self-employment offer, or any other credible source of income available to them will meet the test. Paragraph Gen 3.1, 3.2 of the financial requirements, and it's quoted from the Home Office Family Policy on Family Life as a Partner or Parent 2024. Now the question. Let's see if I can pick the question. So then I take a break and come back. Yes. 𝗖𝗢𝗠𝗠𝗨𝗡, a British citizen who wants to bring her partner to live with her in the UK, she was told that she would have to earn 18,600, increasing to 29,000 from April 11 per annum before she could bring him. AC doesn't work now, but has an offer of employment with an income of 30,000 starting in 2 months. They also have a 2-year-old child with autism. What advice would you give AC? She doesn't earn the required income, so she cannot bring her partner. Is that what you say? Or would you say AC can use her offer of employment if it's a credible guarantee of sustainable income and would be available to her? Or would you say to AC that she has to wait and work for 6 months before she can apply? Put your minds to this. Put your mind back to the nugget. Maybe I can go back to that and give you a bit of a clue. And remember, at a point, Uncle Ben mentioned the answer one way or the other. Not meeting the income requirement threshold cannot be used as against the person, because if the person can identify a credible source of financial support, promise of employment or self-employment, or any other credible source of income available to them, will meet the test. So think about it. It's still the community and the law. And our resource person is a senior partner of BWF Solicitors, Mr. Bernardo, so Uncle Ben will call him. And he's taking us through the new statement of changes. He's taking us through the updates that were made available to you earlier in the week. And now he has asked me to test you whether you listened and you learned. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Okay, well, I thought I was going to do something else, but the machine said to me, come back. Once I'm back on, and I would want to go to the question again. Now, 𝗖𝗢𝗠𝗠𝗨𝗡 is a British citizen. She wants to bring her partner to live with her in the UK. She was told that she would have to earn 18,600, which would increase to 29,000 from the 11th of April. And this is money she has to earn in a year. AC at the moment doesn't work. But she put in an application, went for the interview, and now she has an offer of employment. And they're going to pay her £30,000 a year, starting in 2 months. And if we say 2 months, we're in March, so April and May. Now, the amount is increasing to 29,000 from 18,600 from the 11th of April. So it means that well into the new period, she would have an offer of a job, or she will start her job that will give her £30,000 in a year. 𝗖𝗢𝗠𝗠𝗨𝗡 and the husband have a 2-year-old child who has autism. What advice would you give 𝗖𝗢 with a scenario? Would it be that she doesn't earn the required income so she cannot bring her partner? Would it be that 𝗖𝗢 can use her offer of employment if it is a credible guarantee of sustainable income and would be available to her? 𝗖𝗢 has to wait and work for 6 months before she can apply. Is that what you're going to tell her? I'll drop your answers. Let's go. 0208-493-7345. You can call and tell me the answer and give me your reason, or you can put that in our comment section and we'll pick that one up. You can put that in a text message and send it to us, or send it via WhatsApp to us, 07950422780. Now, Justin says she needs to show pay slip of 6 months. That is C. That's Justin's answer. Eugene says C. 𝗖𝗢 has to wait and work for 6 months before she can apply. Okay, that's your answer. Let's see what else. Josephine says C. 𝗖𝗢 has to wait and work for 6 months before she can apply. Josephine changed them. Brought in B. 𝗖𝗢 can use her offer of employment if it's a credible guarantee of sustainable income and would be available to her. My answer is B. That's what David Asamoah is saying. That's what I just read. B is the answer. Evelyn Asima says B the answer. Yes. Let's go on to the other one. Maybe somewhere B is the answer. Okay, that's your answer. Ebenezer Omwano. AC can use an offer of employment if it is a credible guarantee of sustainable income and would be available to her. Let's see what else has any answer. I believe. Annie, you believe? Be specific. I believe the answer is B, please. Okay, well, we'll put that in there and see if you got it correct. Mabel says it's B. AC can use her offer of employment if it's a credible guarantee of sustainable income and would be available to her. Foster Siama, the answer is B, Uncle. Okay, well, let's see. We'll go to Uncle for the answer anyway. Thank you, Uncle. I'll choose option B as my answer. Give you a chance. Why? Why would you want to choose B? You say AC can use her offer of employment. Okay. George Asari says it's B. Okay. Well, let's see what else we have. Answer is B. Eddie Murray. The answer is B. Okay. Well, let's see. We'll go to that and get the explanation. Emmanuel Nana Kwame Ampiao. B. Well, thank you. Next, B. Lawrence Eje Kwakwa. Thank you. You guys have contributed so very well. Thank you so very much. I'm loving that. Reverend Dodge. Is it Dogbe or Dodge? Dogbe. Okay, it must be a spelling mistake there. But Reverend Dodge, I would have. What are you dodging? In front or behind the altar? Well, Reverend Dogbe says it's B. So, well, let's move on with that. Thank you, Reverend. Yauntimba for B. Okay, AC can use an offer of employment if it's a credible guarantee. Doreen Mochia Owusu says B. Okay, Doreen, thank you very much. Santiago Munez, B. Okay, thank you. Next one, Richard B. Enin on YouTube platform. Thank you very much, is B. Okay. Georgia, sorry, you have Tilly Duma says is B. Okay. Plenty of answers. Sandra Fraser. Oh, you're asking. Sandra, is it B? I know you say, oh, Uncle Keku. Well, Nyakua Amua says is B. Okay. Next one, we have Joseph Akole, B. Okay, so it looks like B is a very popular answer. So, what would I choose myself? Uncle Ben, what's the answer?
Well, very interesting.
Right.
Now, the C obviously is the safest answer. Mm-hmm. So if you want to be non-committal, you say, oh, AC, in spite of the fact that you've got a child with autism who needs all your attention and care, you know what? Leave him and go and work full time and wait for 6 months and ask your husband to also wait. Mm. But let's go back to the nugget. And the answer is in the nugget. So first of all, where the minimum income threshold cannot be met using a source specified. Mm-hmm. So when you look at Appendix FM, there's Appendix FMSC, which is a specified evidence. You can use a credible guarantee of sustainable financial support. Let's stop there. Mm-hmm. Credible guarantee. What has she been offered? She's been offered employment, which starts in 2 months. Mm-hmm. Is it a credible guarantee of sustainable financial support?
Well, the employment offer says they're going to pay her $30,000.
And is it an employment or self-employment offer?
Well, it's an employment offer.
And or is it from a credible source of income available to meet the test? So these are the questions you ask yourself. Mm-hmm. If we go back to the question, Asiata, British citizen, just be mindful that she's got a child who's got autism. Mm-hmm. When we look at GEN 3.1 and 3.2, that is specific to such situations. Okay. So 3.1 is credible source of income which is guaranteed and sustainable. Credible, guaranteed, sustainable. Credible, guaranteed, sustainable. If it is credible, guaranteed, and sustainable, then you meet the test. She has two things going for her. She's got a child who's got autism. Now, autism in this country is a disability, and every child who has autism, the parents will be receiving some form of incapacity support. So the child obviously has a need which ought to be looked at. And for us, it's very key that the parent should not do anything that will aggravate or emotionally remove herself from the child, and leaving the child to go and work full-time and waiting for 2 months to work full-time. It may be that is not the best thing for her. And it may be that if the husband is here and the husband stays home to look after the child while she goes to work in this job, it will be the preferable option. If you ask me, the best answer, since the offer of employment is coming from a credible, guaranteed source of income and is available to her in 2 months, that will be the answer, and the answer is B.
I have a little concern here. Credibility. Proving it might be quite arduous, in the sense that I would bring in an employment offer letter and say that I have this, and I'm anticipating that in 2 months I'll be given a job, which will give me an annual salary or wage or income of £30,000. If the caseworker has any reason to doubt my employment offer letter, how do I challenge it?
Okay, so when we say credible and guaranteed, so Enyidado corner shop on West Green Road, the whole year their income that they've declared for the past 5 years is £10,000. Enyidado grocery shop offers Amata a job for 30,000. Just do the maths. Is it credible?
No.
For 5 years, they've declared an income of 10,000, and they want to pay somebody 30,000. Obviously, that's not credible. BT, British Airways, Sainsbury's, Tesco's has offered Amma a job for 30,000, starting in 2 months. Now, there's no argument about that, is there? That is how you derive your credibility. So when there's a case law, which I haven't cited, which we use to prepare some of this, they're very complex cases, and they're very, very emotional when you're dealing with these cases. What you need to do is to provide your best evidence. So even if your uncle, your brother says that I will support them when the husband comes, they will have to provide bank statement for at least 6 months. And then the source of income. I will even go further to even show that if it's money that they've saved over several years, we will show that. If it's money that they've got from investment, we will show that. If it's money that they got from inheritance, we will show that. This will help you show that it is credible. Sustainable. So when you come to do the sustainability test, if it's 18.6, you work out on a typical week. So they've got an offer of 60-something thousand, or maybe 100,000. This person says, I will look after him for the next 1 year until he finds a job. And they've shown 100,000. You potentially have to provide evidence of 62,000, but they've got 100,000.
Okay.
Those are the evidence that we're talking about. The other part is the Article 8 case, and that one you need to drive it hard with medical evidence and independent social workers report. So if I've got a child who is autistic and they've got challenging behavior, they would have had a SENCO report. SENCO, as you will know, that is a special education coordinator, and usually will be the person who will do the assessment. Some people do their private assessment. You might have a private child psychologist or pediatrician who can do the assessment. Once you've got your medicals, you've got your social report, you can attach that as a reason why, if the husband is refused, it will cause an inordinate, suffering for the child, or that it will breach Article 8. It's a complex area, but I want everybody to focus on the outside box solutions. Because every time, you need to earn 18.6, it's not everybody who earns 18.6, but they might have something peculiar in their lives. You must use that to support. And that's why this question has come. This week's question, again, is something that will help you to solve this conundrum. And that will come on Monday. So the answer is there.
Right. Well, another thing a bit outside of our quiz, but let me help this guy. It says, well, unfortunately, my friend, I can't put your screenshot on our screen because it contains some very personal data that I can't do that, and it's got your photograph on there. You haven't given me the permission to put that one on, but I can get some information off the document and give to Uncle Ben. He says he has a report, a test report for skills for English, SELT, and he's asking. Well, he got a test report and he's passed with merit in 4 areas: listening, reading, speaking, and writing. Now, he says that I know that it is IELTS, but I have got CELT. Can I use this in my application?
Well, CELT and IELTS is the same thing. CELT is a secured English language test. So once the word secured in there, it's fine. The IELTS is International English Language for speakers of whatever, ESOL and all those things. The Home Office has specific English portals and recognized providers that you have to use. Once as one of those providers and you're using the specified test, whether the level is A1, A2, or B1 or C1 for those people who are coming to do masters and PhD, then that should be okay.
Okay. Yeah. This one he did it in he had B1.
Yes.
Listening, reading, speaking, and
but
writing.
We should
B1.
be careful. You can get a B1 and you can get a pass. The pass mark is 5. Is it 4.5 or 5? If you're using 4 modules and they've told you to do 2 modules and you're using 4 modules, you need to get that 5 in all the 4 modules.
Okay.
But they ask you to do speaking and listening. So if you go and do speaking, listening, reading, and writing, you may have overall, you may have a pass, which is a 5. You may have 6.5 here and 3.5. 3.5 is a fail. And for us, we always advise people to be very careful.
Oh, okay. This, permit me. He says pass with merit. So it means it might be above average, maybe?
Pass with merit is overall pass.
Oh, okay.
So individual marks, what did he get for individual subjects?
Interestingly, the report he has provided, I wish I could put it on there, but unfortunately for GDPR purposes, I can't. For all 4 of them, each one it says pass with merit, pass with merit, pass with merit 4 times. So I'm assuming that probably he got a bit of a higher mark for each of them. Well, unfortunately, as I said, I can show you Uncle Ben the thing in the studio, but I can't put it on the screen. Sorry about that, my friend.
Yeah, the SELT, that's fine. But if he's passed and is equivalent to B1, and he's done 4 modules, but he only needed to do 2. He's done 4. He needs to pass it all the 4. So the individual marks that I will be interested in.
Okay. All right. My friend, if you can provide us with further details, will be quite interesting.
And also the name of the provider. Who was the provider? He didn't say.
It didn't say. It says
Pearson, Trinity College. It doesn't say.
It doesn't say it. It doesn't say it. I think it's probably why he wants to find out whether he could use that or not. If you have any further question, you can call BWF Solicitors, or you can call KT Educational Consult, where our dear sister Maya T also helps with that. So then she can advise you on those things. Well, Uncle Ben, I think it's about time we did our traditional thing where we have a brief summary of what we have discussed this afternoon.
Okay, so obviously the reason why we've chosen today to do a deep dive is whatever is coming affects all of us. So if you take the financial threshold, whether you're British settled or now to settle, you may bring a spouse or you may bring a partner. It affects you. If you're a business person and you are applying to employ someone here, the new immigration salary list obviously brings a higher threshold up to 38,600. The lowest is 23,200. When I did the maths, I think the hourly rate was about £12 for care workers. All these are relevant. In addition to that, EU nationals and EU family members who may have suffered domestic violence, even if your marriage is a few weeks old or a year and your time here, you haven't reached the 5 years, you've been added to those who can apply for indefinite leave straight away. Also, you've also been added to those who can apply for the former what we call DDV, which is the domestic violence destitution route, which will allow you to make an immediate application by email. And when you're making your main applications, you don't pay the 2,885. The other thing that I also want people to know is that the English language provision, they've added international GCSE, or it's GSC, whatever. It's the same as GCSE. They've added that. These are areas that we need to know. Shortage occupation is going out. Plus stress have been taken out. All those people who wish to bring their partners here. If you want to bring your partner and you know that you haven't got any compassionate circumstance and you will not be earning 29,000 on the 11th of April, put in your application before the 11th. Don't leave it too late, because making an application without evidence, you're calling for a refusal. Just remember that the transition arrangement covers those whose application is subsequently successful. So if you put in before the 11th and your application is not successful in June, you obviously cannot take advantage of the protection. The final part that I want to dwell on is that in all this, everything that has been said, there's a solution. So be it using your dependent child because it's over 18 and is working, and it can bump up your income to meet the minimum income threshold or minimum income requirement, or if you have an offer, or maybe you've got a friend who's rich, so you want to make your application, you're earning 14,000, even 10,000. Your friend has got about 60,000 pounds sitting in the account. They can write a small agreement and give it to you as what do we call it? A grant or a gift, and you can put it in your account and show. Now, I'm not saying that, deceive, but again, if a friend wants to help, these are things that they can do to help. Maybe you've got a father who has a spare cash in his account. He cobbled together with your mother and they put together maybe a spare cash of maybe about 25,000, and they say that's available to your husband when he comes. Or perhaps you've got a child who's got a disability. You still want to bring your husband. Like this old man who's on a PIP and he still wants to bring his wife because he's going through a lot. He lost his wife not too long ago, and he's married this other woman who wants to come and keep him company. Again, these are things that you can do. So every area of law, there is a solution. The only thing I ask you not to do is to forge and create things and lie, or use people who are unqualified because they don't understand the law, and maybe their interest is not your interest. Then it leads to so many things. There's so many things that we see in this space. Just that sometimes when we come here, we don't want to talk about it. But whatever it is, the new law is here. We can't wait for the elections to come so that this area will rest for a bit. Over the last 2 years, almost every 3 months, there's a new law. And hopefully, once the election is called, today, one of the parties were in my area when I was going to the gym, and I asked them, which party are you? And they told me. And I was saying to myself, they are all the same. But the bottom line is that whatever the problem, we may have the solution. The solution will lie in the law or in the guidance notes, and we will always point you to the right direction. Thank you very much.
And thank you very much to you out there for sticking around for the past 2 hours to listen to what we have, and also to increase the amount of knowledge you have. And to you, Uncle Ben, I want to say thank you so very much for making time to come around and teach us what it is that we needed to learn. To my producer and director, studio manager, Professor Ade, thank you so very much for your time and your dedication. To Sheila and Padmododu for the aesthetics and the administration. To all the family members of BWF Solicitors, I want to say thank you so very much. To you out there, I say Keep doing what you're doing. Stick with us. We'll be back again same time next week with another edition of the Community and the Law. My name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬. Have a good evening.